Welcome to the Renting in Seattle webinar. My name is Dulcie O'Sullivan. I work with the Seattle Department of Construction and Inspections, and today I will be co-presenting this workshop with my colleague Mike Chin from the Seattle Office for Civil Rights. Also joining us today is Maureen Rote, Compliance Supervisor with SDCI. She will be assisting in moderating the questions portion and providing some expertise during the webinar. Today we will be discussing renting in the time of COVID-19. We're going to provide an overview of eviction moratoriums and some other tenant protection legislation that is temporarily in place because of the civil emergency.
And I will cover the impacts of COVID-19 on housing and fair housing responsibilities for housing providers and the new COVID-19 protections that amend the Fair Chance Housing Ordinance. Also, after the training, if you leave with any unanswered questions, please remember you can always contact us at Renting in Seattle at 206-684-5700 or visit us at seattle.gov/renting in Seattle.
So we're going to begin with the eviction moratorium at the state level. This was issued by order of Governor Inslee. Currently, it's in effect until August 1st. It bans all residential evictions except for the following: when there's an imminent threat to health and safety, when there's significant property damage occurring that was unknown to the landlord prior to COVID-19, or when the owner elects to sell or occupy the rental and provides 90 days advance notice. Transitional housing is also covered, leased lots for mobile homes and campsites, as well as some less traditional occupancy situations like hotels and motels of stays of 14 days or more. The eviction moratorium also bans enforcement of agreements to vacate. It prohibits landlords from moving tenants to a lesser unit if they can't afford to pay the rent that they have for their current unit. It prohibits late fees, threats of late fees, or any charges for non-payment of rent effective February 29th onwards. And it prohibits charging for units that did not become occupied due to circumstances around COVID-19. It prohibits charging for units that were left by renters due to COVID-19 needs of their own or others. It suspends rent increases and increases to security deposits. It also establishes that owed rent cannot be pursued as collectible debt or through any court action unless the landlord can show the tenant was offered a payment plan that's reasonably based on their specific circumstances and refused to enter into a plan or failed to comply with the terms once agreed. The eviction moratorium that is issued at the city level was issued by Mayor Durkin effective March 16th. It will also extend to match the state moratorium to August 1st. And it bans residential evictions, termination notices, or any action to proceed on a termination notice except when there is an imminent threat to health and safety. It prohibits late fees and charges. So we're getting a lot of questions from landlords on a daily basis in our helpline, and we have summarized some of those questions here with the hope that it will answer most of what you're needing to know. Just remember, as Mike said at the beginning of the webinar, any questions you have that are not answered during this webinar, you can always call the helpline at 206-684-5700, and there'll be somebody there that can help you. So first question, what can I do if my tenant's lease is ending? Can I raise the rent if they sign a new one? The answer to that is pretty straightforward. The answer is no. There is a rent freeze under the current moratorium. So there are some solutions you can think about, maybe signing a shorter term lease for the same rent that you're charging the tenant now. And then once the emergency order is over, the civil emergency is over, entering into a new lease agreement with appropriate notice of that rent increase. Another question that we're getting a lot is, what if my tenant requests repairs? Do I need to, and can I go into their unit during the stay home, stay healthy order? So even though we are going into different phases as we go through the recovery period, nothing has changed with regard to obligations of landlords about repairs. If there is a repair need, the tenant should be submitting that in writing, and you will need to respond accordingly. Obviously, it's best that you follow all the CDC guidelines, Department of Health guidelines, wearing masks and trying to maintain that 6-foot distance, but just follow the current guidelines. But repairs are an obligation that still remains under the circumstances.
Dulcie, this is Green.
Yeah.
I wanted to clarify 2 things on the first question. What can I do if my tenant's lease is ending? Foremost, as Dulcie said, you cannot force the tenant to vacate if their lease is ending. However, how you choose to move forward with that lease can impact protections that the tenant has after their lease terminates. So you do want to be sure that if you are entering a new lease agreement or choosing to go month to month, that you consult with an attorney to understand what rights those tenants will have based on how you move forward. The second is, I just wanted to clarify on raising the rent if they sign a new lease. You cannot increase the rent during the moratoriums. However, it's not a rent freeze in the sense that rent is not being collected. It is still being collected. It is still owed by the tenants. And tenants are being encouraged to continue to pay rent as they can moving forward while the moratoriums are in place.
Thanks for that clarification, Maureen. Maybe you'd like to answer the next question, which is, what can I do if my tenant doesn't pay the rent?
So again, if the tenant doesn't pay the rent, the moratoriums currently do restrict the service of a 14-day notice for non-payment. So you can't do that during this period of time. You can speak to the tenant about a payment plan. You do have to be careful when doing this because the moratorium also prohibits any threats that seem to sound like you will move forward with an eviction if they do not pay. But landlords and tenants are encouraged by the moratorium, particularly at the state level, to engage in conversation around payment plans moving forward.
Next question, what can I do if my tenant is causing problems with other tenants? And the example here would be noise disturbances. So under the current moratoria, that would not be something that you could move forward with an eviction on. It wouldn't rise to the level of an imminent hazard to health and safety, nor the other conditions under which it would be permissible to move forward with an eviction action. So the best thing you can do at the moment, under the current circumstances, is to communicate with your tenant, let them know that there have been complaints, and hopefully that will resolve the matter until such time as you would be able to issue an appropriate notice, such as a 10-day comply or vacate notice. Do you have anything to add to that, Maureen?
I wanted to add 2 things. The first is, if these instances are rising to a level that may not be a threat to health and safety, but there is a lot of disturbances happening and tenants are complaining, you do have the option in that circumstance to contact the police. It's only to be done, of course, in serious circumstances that just might not rise to the level of imminent threat. And in addition to that, if you are working with tenants who are having disputes among themselves, you may suggest to them that they engage in dispute resolution programs The county does have King County Dispute Resolution is a free program for people who cannot afford it. It's sliding scale based on income for other parties. So it is a resource that is available if you are having tenants who are having disputes among themselves, or you as a landlord are having a dispute with your tenant that you'd really like to try to resolve.
Thank you. Do you want to take the last question, Maureen? What can I do if my tenant agreed to move out and now will not move out?
At the current time under the moratoriums, even if your tenant had signed an agreement to vacate, or they proactively approached you and said, my plan is to move at the end of the month, at this time you can't enforce that agreement with the tenant. They cannot be forced to move out. They cannot be subject to an eviction during the moratoriums for failure to move. And again, how you proceed forward after the expiration of the time when the tenant said they were going to vacate can impact your rights and your ability to move forward after the fact. So again, if you are in this situation and you have a tenant either with an expiring lease or a tenant who has given you notice that they intend to vacate, you will want to consult with counsel to find out about the consequences of doing things like collecting rent or signing a new short-term lease agreement, with the reminder that in that short-term lease agreement, you would not be able to increase the amount of rent that's paid by the tenant.
Thank you, Maureen. So what's next for the recovery period? City Council recently passed 3 bills aimed to try and help folks who are struggling during this period. The first Council Bill 119784 establishes that non-payment is a defense to eviction within 6 months of the moratorium expiring. Under this particular defense to eviction, a tenant must certify financial hardship and an inability to pay the rent due to COVID-19. Any 14-day notice that you issue at that point must include the following language. If you cannot pay rent during or within 6 months after the end of the mayor's moratorium on evictions, your inability to pay is a defense to eviction that you may raise in court. Remember that deficient notices without that language also establish a defense to eviction, and there are no attorney fees awardable in this situation. Council Bill 119788 requires landlords to provide the option of payment plans during and up to 6 months after the civil emergency ends. So if your tenant is between 1 and 2 months overdue with their rent, they can avail of a payment plan that is between 3 to 5 consecutive equal monthly installments. If they are 2 months and over delinquent with rent, then they can pay up to 6 consecutive equal monthly installments. Alternatively, you can agree with your tenant on an alternative payment plan schedule as long as it's mutual. The payment plan will become part of the rental agreement. And again, no late fees or interest allowed for up to 12 months after the civil emergency ends. So remember again, with the 14-day notices, you must also include the following language. City law entitles you to pay overdue rent in installments. If your landlord does not accept payment according to the installment schedule, you may raise this as a defense to eviction in court. And again, deficient notice or refusal to enter into a payment plan provides defenses to eviction, and there are no attorney fees awardable under those circumstances. So we'd like to remind you, because we know that this is a very stressful time for landlords, particularly small landlords, that this situation is temporary. It's not rent forgiveness. Tenants are still obligated to pay rent. We do have an FAQ for tenants that's translated in 12 different languages available on our website, Renting in Seattle. and you be well advised to distribute that amongst your tenants so they understand that they are still obligated to pay rent. There are programs and resources for landlords facing financial difficulties. We have a resource list at the end of this webinar that you can access on seattle.gov/renting in Seattle also. And then the last thing is working out your issues with tenants where possible is likely going to cost less than paying for an attorney and court expenses where the outcome is ultimately out of your hands. And so we just strongly encourage both landlords and tenants to meaningfully engage during this difficult time and figure out a way where rent can be paid until such time as things stabilize. And with that, I'm going to hand the webinar slides over to my colleague, Mike.
Thank you, Dulcie. So in this next step, I wanted to cover the fair housing protections provided under fair housing and also cover the new COVID-19 recovery protections under the fair chance housing. But I actually think it's really important that we start to talk really about and focus around what are those racial impacts of COVID-19 in King County. So there was a recent article in the Seattle Times on May 1st that really focused on what were those impacts and racial impacts in King County itself. And so one of the things that King County is not at all unique at all to what's going on in the rest of the United States. Nationally, COVID-19 disproportionately affects communities of color, particularly Black communities, both in cases and deaths. And that is something that we have seen not only the infection rates, but also the mortality rates from what is happening with COVID-19 across the United States. Particularly to King County, what we have seen is that Hispanic folks have died at almost 2.5 times greater than white individuals in King County. And also for Hawaiian Pacific Islanders have also had a higher infection rate compared to the rest of the community here in King County as well. And that is something that we have seen not just here in Seattle and in King County, but across the country itself. And for African Americans, that number is also greatly increased as well in terms of the infection rate. And so when you have these sorts of rates where they show a disproportionate impact on racial groups, what it shows is that there is a real inequity that is occurring that is not just on health related issues, but is also connected to access to housing and jobs. And in this chart, what you will see is that there is a huge disproportionate, even though that the white population in King County only makes up 58.7% of the population, the infection rate is much lower compared to the African American population, the Latinx population, and even the Native Hawaiian Pacific Islander populations. And these disproportionate impacts not only just people's access to healthcare and also people's ability to get appropriate housing. There's a lot of reasons for these different things, different reasons for these disproportionate amounts, and a lot of it has to do with people of color are mostly in essential work type, and they're also in service-related industries. And it also shows that there is people what they're in terms of access to jobs, lack of sick leave, they rely on public transportation, and also underlying health issues, and also being able to think about like who actually has access to health care and health insurance. In a different study that was shown, Zillow put together a study about what are those impacts of coronavirus layoffs have huge impacts on both Black, Latinx, and Asian households. And in this article, a housing conducted showed that compared nationally, and these are in some of the largest cities across the United States, Seattle was not included in the study because the race demographics were only available for King County. But what it did show was that there was a disproportionate amount of what rent burden was. So the chart shows the share of income spent on rent for white households and non-white racial groups were the largest difference from white households. And rent burden is the percentage of income that goes towards rent expenses. And what the study found that workers in industries on the front lines of job losses and furloughs, notably food and retail, are feeling an especially acute pinch as months without income leave them more vulnerable to unsustainable living costs. Among the most troubling trends to emerge from this pandemic has been how the virus and disease itself has disproportionately impacted communities of color. And in addition to the public health disparities, the economic impacts of the coronavirus outbreak are also experienced very differently across racial lines. And in virtually all of the national largest metros, Latinx and Black rent households face larger rent burdens than other racial groups. And that is where Latinx, Asian and Black workers are disproportionately represented in the foods, arts, and service industries that have all been affected by mass layoffs and furloughs. And non-white households in these industries were more cost burdened than white households before any loss of wages, meaning that they are potentially more vulnerable to experience housing insecurity after missing pay. So when you overlay health, jobs, and housing, Blacks and Latinx are substantially disadvantaged by COVID-19, and which widens the wealth gap and housing access for people of color. Overall, what we have seen for the last couple of months with COVID-19 is that no one is immune to COVID-19 virus, and it can affect anyone regardless of your race. However, the financial, the housing, the job impacts disproportionately impacts communities of color based on socioeconomic inequalities that exist. And with COVID-19, it actually makes the disparities even greater. And not just in terms of access to healthcare, but also access to jobs and housing. That is why it is so important that providing stable, safe housing for everyone is vital to making our communities more equitable. Remember that we cannot at all achieve equality without addressing inequities that exist in our housing. Fair housing laws promote equality, which prohibits discrimination based on race, national origin, ancestry, color, sex, disability, sexual orientation, gender identity, religion, creed, age, housing subsidies, alternative sources of income, familial status, marital status, veteran and military status, and the use of a service animal. And discrimination includes different treatment, disparate impact, failure to provide a reasonable accommodation or modification, harassment, and retaliation. Equity is about focusing on outcomes that make everyone have equal access to housing. By focusing on outcomes and inequities in healthcare, jobs, and housing, we can begin to address the structural and systems of racial oppression in our community. In the Renting in Seattle training curriculum, we will go into further detail and provide examples of each type of discrimination and housing providers' responsibilities under fair housing laws. I'm going to talk a little bit about a new law that passed on May 10th of this year. So Seattle City Council passed a new law which amends the Fair Chance Housing Ordinance 1409, which prohibits landlords from taking an adverse action against a tenant based on eviction history occurring during or within 6 months after the end of the civil emergency proclaimed by Mayor Durkin on March 3rd, 2020. That basically means that landlords cannot take an adverse action against a tenant or potential tenant based on their COVID-19 related eviction history. This refers to any eviction history from the start of the civil emergency and for 6 months thereafter. It applies to all rental housing, including DADUs, ADUs, and single-family dwellings. And what the also law expands includes the definition of eviction history to include eviction court filings, issuance of eviction notices, and any notification of an intent to evict. And it requires specific notice to prospective tenants to include the following language in their application. And that language is: the landlord is prohibited from taking an adverse action against a tenant based on eviction history occurring during or within 6 months after the end of the civil emergency proclaimed by Mayor Durkin on March 3rd, 2020. And it also informs, the law is also enforced by the Seattle Office for Civil Rights to enforce any violations of this ordinance. It also creates a rebuttal presumption that a landlord who sees the history has used it in reaching an adverse decision if it affects a potential or a current tenant. There are some exemptions to this law, and it creates an exemption for imminent threats to health and safety and other situations already exempted from fair chance housing coverage. For example, if there was a person who was evicted because it created a health or safety impact to property or to individuals on the premises, that could be exempt from the coverage, and a landlord could take actions based on that. That is a very high bar to show imminent threats, and it actually is not just imminent, but actual threats and documentation of it actually occurring. It also exempts federally assisted housing, but it is really narrow. It must comply with the ordinance. However, there is an exclusion for adverse action when denial of tenancy is required by federal regulations. So remember, just because you're getting federal housing or you're protected under federal assisted housing, you would likely still have to follow the local ordinance unless the federal regulations prohibits otherwise. The following section explores what qualifies as federally assisted housing subject to federal regulation that require denial of tenancy and some other requirements. Just remember that if you have specific questions around these new protections, please visit us at www.seattle.gov/civil rights, and there's more information. And for specific information around this new provision, you can also email us at discriminationquestions@seattle.gov or call us at 206-684-4500. So here's some other things that we also wanted to cover for fair housing tips. So some of the common questions that we do receive, especially during COVID-19 time, and some things that you should remember is that having COVID-19 is protected under disability, because both Seattle and the state Washington definition of disability includes individuals who are diagnosed with COVID-19, and it could also include people who are perceived to have COVID-19 or associated with someone with COVID-19. So remember in that definition that you don't actually have to have COVID-19, but if you had a record of, if you are perceived to have or associated with someone with COVID-19, you are protected under fair housing laws, and you can have a right to file a complaint if you believe that a landlord is taking an adverse action or refusing in some way from you getting coverage under fair housing. The other thing to remember for housing providers is you cannot treat individuals differently based on their disability. And that is true with individuals with COVID-19. If you know that someone has COVID-19 or has shared that with you, and of course that is private information, but if they do share that with you, and you cannot treat them differently. You may provide them different options about providing different services in terms of maintenance. If you have to go into their unit, you may need to prepare your staff. You may need to also maybe keep the premises more, wipe down door handles, make sure that things are a little bit cleaner to make sure that to prevent any sort of spread of COVID-19. But these are some responsibilities that landlords must know, that you cannot direct the different treatment towards a person with the disability. Also, another thing about disability law is that if you are a person with a disability and the person requests for a reasonable accommodation, you must engage in the interactive process and provide a reasonable accommodation if it is reasonable. So even in a situation with someone with COVID-19, if they are, because of their infection, they're not able to, they're asking for a change in their policies or practices by the housing provider, you must engage in that interactive process to be able to assist them so that they can enjoy their dwelling. Also, as a housing provider, you have a responsibility to prevent discriminatory harassment on your property. This includes tenant-on-tenant harassment based on a disability. And so if you know that if someone is suspected or has COVID-19 and you hear about tenants harassing another tenant because of their status, that you as a landlord have a responsibility when you are on notice, either actual or constructive notice, to take action. And also remember, retaliation based on disability is prohibited. In the Renting in Seattle training curriculum, we'll go into further detail and provide examples of each type of discrimination and housing provider responsibilities under these laws. And something that's new on our website at the Seattle Office for Civil Rights is that we have now an anti-bias hotline. Xenophobia, racism disrupt the safety and resilience of our communities by misdirecting fear and anger towards people instead of the root causes of harm. This can result in bias or hate incidents targeting neighbors, business, or communities. We all play a role in creating communities free of hate, bias, and exclusion. It is important for us to understand what bias is and what to do if we experience or witness an act of bias. A bias isn't any incident that is directed at you because of your race, religion, gender, or gender identity, sexual orientation, disability, national origin, age, creed, and more. It can include things like racial, ethnic, or sexist slurs, intimidation and cyberbullying, telling jokes based on stereotypes, xenophobic or racist graffiti or images. If you experience or witness an act of bias, please report it to the Seattle Office for Civil Rights Anti-Bias Hotline at 206-233-7100, or you can also report it online on our bias incident reporting tool. Reporting is easy and can be done anonymously. Remember, if there is any issues of physical violence, property damage, or threats, may be a violation of criminal law and must or can be reported directly to the police by calling 911.
Hi, Dulcie. It sounds like you need to unmute your mic.
Thank you. So that concludes our webinar for today. Thank you for attending. Thank you for checking this out on the website. This is a list of resources for landlords. You can also find it on the Renting in Seattle website. If you have any questions or you need help understanding any of this information or any other information relating to your role as a housing provider, please feel free to reach out to the Renting in Seattle helpline at 206-684-5700. We welcome your questions and we thank you for sticking with us through this very difficult time. Thank you.